And then do you know who's handling Mr. Marino and Ms. Poliandro? Poliandro is you, right? Do we want to bring her up in person from, is she in the jail?
She's in jail.
And then Mr. Marino's in the jail too. Are you doing that arraignment?
I could, but an attorney, I was set to arraign him on another case last week, and
Oh, Eric Perney was his retained. So you think Perney might
he
appear
might.
today?
Otherwise, I would have to have a small discussion. I'm aware of the probation. It's a probation violation, this is?
Yeah. So you've got Mr. Perney zooming in. All right, up next, we've got People of the State of Michigan versus Jacob Vincent Marino, file 24-93301FH for an arraignment on a probation violation warrant. Counsel, you want to state your appearances, beginning with the people?
Jeremiah Buffalo, word on behalf of the people.
Hey, good morning, Your Honor. Eric Perney, on behalf of Mr. Marino, P79467.
All right, good morning. And Mr. Perney is zooming in and Mr. Marino is appearing by video from the Prescott County Jail. Let me know, Mr. Perney or Mr. Marino, at any time if either of you desire a breakout room, and I can facilitate.
Sure, thank you.
All right, so Mr. Marino, it's alleged that you're in violation of your probation in four counts. Count one alleges that since your placement on probation on October 7th of last year, you have left the state of Michigan without consent of the court. Count two alleges that since your placement on probation, you have used and or possessed alcoholic beverages. And count three alleges that on or about July 7th, you engaged in assault of this year, 2025, you engaged in assault of abusive, threatening, or intimidating behavior against one Brooke Mishley. Count four alleges that in violation of condition one, you violated the criminal law by committing an assault against that same person. You have the right to have a hearing on these allegations where they would need to be established by a preponderance of the evidence. You have the right to the assistance of your attorney, and Mr. Perney is here representing you. If you couldn't afford an attorney and petitioned, you could be eligible for an attorney at public expense. You have the right to present evidence at that hearing and to cross-examine any of the witnesses presented against you. You are on probation to me for a charge of fleeing and eluding in the 4th degree. That is a maximum penalty of 2 years in prison. Count four is a non-technical violation, meaning if you are found to be in violation of count four, then I could revoke your probation and sentence you on that underlying offense. Counts 1, 2, and 3 are all technical violations. Those being separate technical violations, that would mean that as long as you have no prior technical violations, which I think you don't have, that would be a maximum exposure for 15 days in jail for a first technical, 30 days for a second, 45 days for a third technical. Mr. Marino, do you understand the maximum penalty that you could face and the rights that you have in this matter?
Yes, Your Honor.
And Mr. Perney, do you know how he wishes to plead?
Yes, Your Honor, thank you. My client will stand mute and ask the court to enter a not guilty plea for those violations.
Okay, we'll enter a plea of not guilty and schedule this for a probation violation hearing. Do you know, Mr. Perney, have there been criminal charges filed as a result of any of these allegations?
Yes, Judge. So I was appearing before the court with Mr. Marino last week. There was a felony complaint and warrant issued last week at some point. He was arraigned, I believe it was Thursday or Friday of last week. He was issued a $15,000 cash surety bond. The judge did order, if he was able to get released, that he could that you had to have a tether placed on him. During that time, Your Honor, we did waive the 21-day rule at the time of his arraignment. So they did schedule a PCC on or about August 20th, I believe it is. So we have a few weeks before that PCC date. With that said, I'm not sure if the court's so inclined to allow us to, because the fourth count that you just mentioned in the record, obviously, is the most severe, and that's what we're going to court on in August. If you could mirror or give him a personal bond on this one so that he can meet with me, and then we can come back after our PCC date if possible.
Okay, I could schedule this for a probation violation hearing on September 8th. My August date is August 11th, so that would even predate your PCC. So it makes sense to maybe put this on the September docket then.
Okay,
We could schedule that for 11 a.m. And Mr. McLennan, as to any pretrial release on the pending probation violation, what's the people's position?
If I may, Your Honor, I would like to note that as to that count 4, we also have an allegation and a charge pending of tampering with evidence relative to evidence of violations in this instant hearing, Your Honor, or in this instant case. So, Your Honor, we have him tampering with video evidence that equals a probation violation. We have him here on an underlying case of fleeing and eluding, and we had to send our fugitive task force team to go find him for the new cases. Your Honor, he's absolutely a flight risk. He's absolutely a danger to the community. He likes beating up people who might get him in trouble. We would ask that he be held without.
Okay, and Mr. Perney, it's generally my starting point. I mean, I understand it's not like a policy. I do make exceptions to it, but my starting point is if you're on felony probation with me and you're alleged to have committed another felony, you don't actually have the right to be released. What you do have a right is for me to hold the contested hearing within 14 days. So if you insist, I'll certainly do that. But I am at this point not going to release Mr. Marino until further order of the court. And we'll schedule it for a probation violation on September 8th at 11 a.m.
all right, very good.
Okay, have a good day.
You too.
All right, let's talk about that. The probation violation arraignment in People v. Jacob Vincent Marino was a heavyweight session packed with legal tension and no shortage of serious allegations. Judge J. Gauthier presided, and true to form, he cut right through the noise and laid out the landscape with total clarity. Mr. Marino appeared from the Presque Isle County Jail via video, with defense attorney Eric Perry zooming in. The prosecution was represented by Jeremiah Buffalo, and all parties came ready for a procedural chess match. The court detailed 4 alleged violations of probation, stemming from Marino's original conviction for fleeing and eluding in the 4th degree, already a felony with a 2-year max. 3 of the alleged violations were technical, leaving the state without permission, consuming alcohol, and engaging in threatening behavior. But count 4, the big one, alleged that Marino committed a new assault, a non-technical violation that could trigger full revocation of probation and a sentence on the underlying charge. Marino stood mute on the allegations, with Mr. Perry requesting a not guilty plea be entered, and the court obliged. What followed was a compelling glimpse into how new criminal charges intersect with existing probation. Apparently, Marino had already been arraigned the prior week on a new felony likely. The same assault that was count 4 here, and was given a bond with a tether condition. Perry asked the judge to consider a personal bond on this probation violation so they could prepare for the August probable cause hearing on the new case. Judge Gauthier wasn't having it. The prosecution came in strong, citing not only the assault allegation but also a new tampering with evidence charge involving video footage. They added that the fugitive task force had to track Marino down, underscoring his flight risk. And as the prosecutor bluntly put it, Marino likes beating up people who might get him in trouble. Judge Gauthier, while never dramatic, was unequivocal. If you're on felony probation and you catch another felony, especially under these conditions, you're not getting released. He acknowledged Marino's rights, including the right to a hearing within 14 days if demanded, but made it clear that he was ordering continued detention until further notice. All in all, this was a tight hearing with high stakes. Judge Gauthier handled it with fairness but firmness, reinforcing that probation isn't a free pass. Once you're under supervision, especially for a felony, the margin for error shrinks fast. Marino's next court date is set for September 8th at 11 a.m., and it's safe to say that hearing could be even more consequential. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.